Bismillah, Assalamualaikum warahmatullahi wabarakatuh. Hello, I'm Iqbal Fathur and I'm come from Class 1B of Law Department. And here, I want to read the text about marriage law reforms. Major portion of the statutory personal laws enacted in the various Muslim countries represent a mere codification of the established law or, at best, unification of hitherto divergent legal principles. There is, however, no reason to deny the fact that certain propositions in its laws have introduced significant reforms in the traditional law. The principal reforms so introduced in one country or another relate to a. Marriage age for men and women and difference of age between parties to marriage. B. Rule of marriage guardians in the fixation and solemnization of marriage. C. Registration and documentation of marriage. D. Monetary aspect of marriage dowry and expenses. E. Polygamy and right of wives. F. Maintenance of wife, family and matrimonial home during the subsistence of marriage. G. Unilateral divorce right of parties to marriage and ground for judicial divorce. H. Post-divorce life for the parties, especially for women. I. Period of gestation and its implications. J. Parents' right relating to custody and guardianship of children, especially of mothers. K. Inheritance right of certain close relatives, surviving spouse, daughters, brothers, sisters, grandfather, and descendants of predeceased children. L. Choice of the legate, especially their eligibility to receive a bequest, and M. Validity, tenure, and management of family works. Reforms in those have been effective. Different reforms in different countries, either under the proposition of comprehensive codes or laws of personal status or family rights, or by way of sporadic legislation. The search materials for all the aforesaid reforms have been allocated by the jurists and the legislators of the Muslim world in the depth, diversion, flexibility, and richness of the legal principles within the vast framework of the Sharia. It is nobody's case in the Muslim state, including Turkey. The personal law has been codified and reformed merely to modernize or westernize the law. Nor have their activists, advocates, and exponents frequented annually an Islamic search for any of those reforms. The motives behind and the object of all this legislative activity have been elsewhere by the reforms, the need to systematize personal law on the pattern of other laws since codified, the desire to benefit from lesser now and hitherto neglected principles and juristic opinion within the fold of the Sharia, the will to check misinterpretation, misapplication, and growing misuse of the Sharia law, of which there were greater chance and possibility in its uncodified stage, the policy of nationalizing and thoroughly Islamizing the law, and the urge to rebuild the society in conformity with the original, unadulterated legal principles of Islam. In several countries, the ulama have applauded or have been closely associated with the reforms affected. At the same time, some of the reforms in some countries have been opposed and criticized by certain sections of religious leaders and scholars. This has happened in Iraq, Indonesia, Pakistan, Tunisia, South Yemen, and Turkey. On some occasions, their objections were accepted and the reforms proposed are already effective, dropped, refilled, or modified. Maybe just that. Sorry for all of my mistake. And last, wassalamualaikum warahmatullahi wabarakatuh.